Hello, it is Devaney, and I am here again today on Legally Norette, Legally Raven Haired. And, I need to do a video about the ability to apprentice to become an attorney because that's what I'm doing in the state of Vermont. And I don't believe I've really openly said that, but I am actually doing my first 6-month report. And the state of Vermont has the opportunity to submit an essay which they will grade for yeah, they were great. So I've never written a sample bar exam essay. At this point, I don't know enough to be able to write it without looking for the answers. I can't just do it in that timed environment. But what I want to try to do is go ahead and go through some practice questions and some practice answers so that I can actually try one. So I'm going to, there are 6 ones. I'm looking for one that's about civil procedure. So if I find that one, I'll skip ahead and I won't take a look at it because that's what I've really been studying recently. And I want to uh, make sure that that's the one that I don't read the answer until after I already complete it. So I have an attorney that is my supervising attorney. And so I send him an email every week to let him know what I'm doing. And yeah, so the first 6 months actually went fast. I started on December 20th and here it is June 1st today. So my report actually isn't due until July 20th, but I want to get it in right on time. So I'm going to start working on that for the next couple weeks, getting my report together. So part of that report is going to be the essay, and I want to do the essay part first because it's the hardest part. So how did I find these? So let's go here. Let me just go back for a minute. What I did was I went to this from, I think, Brigham Young, and these are study aids for law students, and they actually talk about sample exam questions and answers by state, and you actually become like really current. So the UBE, many of the states on this list administer the UBE, but the states offer more recent model essay answers than the UBE. So we're going to look at Ohio because I'm from Ohio, and yeah, and we're gonna look, why not just look here? Oh wow, they have February 2022. Wow, they have, oh no, these are the how people did from the different schools, first time pass um rates. Yeah, wow, okay. Cleveland State had 10 first timers, 80% of them passed. All right, so that's good to see how many people pass the first time. University of Dayton, 75% of the people passed the first time. Cleveland State, 80% of the people passed the first time. That's good. It's really good. All right, so it looks like you have a kind of a, ooh, Ohio Northern University, this isn't good, but it looks like you have a kind of a 50-50 chance. One University of Pittsburgh, one person they passed 100%. University of Costa Rica, they passed 100%. Vermont Law School, somebody took it and they got 100%. So I'm trying to get licensed in the state of Vermont. So that's great. All right, so these are bar, okay. Okay, here we go. Essay questions. No, February 2022 is not there. So let's go here and let's go. So Supreme Court of Ohio, woohoo, not exactly appropriate where, if you get my drift. July 2021, Ohio bar examination, multi-state essay examination questions and select the answers, multi-state performance test summaries and select the answers. So this is actually 52 pages. Oh, wow, this is really, really good. I didn't realize that this was available. And so this is great. Thank you so much, Google. All right, so what we're going to do here is let's look at the first essay question and see it's about civil procedure. So, question: a mother was shopping with her 6-year-old son at a big box store. The son was visually impaired, so his mother, concerned about the crowding and jostling by other patients, restrained him by placing her hand on his shoulder and instructed him to remain in her grasp. Despite his mother's efforts, the son broke free of her grasp and ran toward a nearby candy display. Because he was running and visually impaired, the son did not notice some cheesecake on the floor in the store's self-service dining area. The cheesecake was flattened and dirty. The son slipped on the cheesecake and fell on the floor, suffering physical injury. Another customer unsuccessfully attempted to help the son to stand, worsening the son's injury by negligently twisting his arm. Big Box had in place a policy instructing employees to take steps to promptly clean known hazards on the floor but it did not assign an employee to monitor floor conditions. Big box employees do not know when their employee had most recently inspected the floor or when the floor had last been cleaned. The self-serve dining area includes displays that contain takeout food, including cheesecake. These displays had last been stocked several days before the sun slipped on the cheesecake. On the day the sun slipped and fell, a store employee had walked by the self-serve dining area before the sun slipped, but had not noticed the cheesecake on the floor. The mother filed a negligence claim on her son's behalf against Big Box and the customer who attempted to help her son. Both Big Box and the customer claimed that the son was negligent. Number one, under the applicable standard of care, are the facts sufficient for a jury to find that the son acted negligently? Explain. Under the applicable standard of care, are the facts sufficient for a jury to find the Big Box acted negligently? Explain. Can the customer be held liable for enhancing the son's injury? Explain. Assuming that only Big Box and the customer were negligent and can be held liable, can the son recover the full amount of damages from Big Box only? Explain. Do not address the effect. Do not address the effect of any Good Samaritan statute. Okay, answer. Son's negligence. The first issue is whether a visually impaired child is negligent if they run into a crowded area. In order to be found negligent, a person must have the duty to exercise reasonable care under the circumstances, breach that duty, and cause damages to another as a result of that breach. To determine whether a person acted reasonably under the circumstances, a court will look to the ordinary standard of care a reasonable person would apply under like circumstances. However, if the negligent child is the actor, the reasonableness of their conduct is assessed against a reasonable child of the same age, education, experience, and intelligence. Regardless of whether the actor is a child or an adult, the court will consider any physical limitations the person has in determining if they act as a reasonable person. Here, the son is a 6-year-old child who is visually impaired. Therefore, whether he acted negligently will be assessed compared to other reasonable 6-year-old children with similar education, experiences, and intelligence. In this case, the boy was instructed by his mom to remain in her grasp because they were in a crowded area, but instead the boy broke free from his mother's grasp and ran toward a candy display. A court would likely conclude that it is not reasonable for a visit. A court would likely conclude that it is not reasonable for a visually impaired child to run into a crowd without their parents when they cannot see. Thus, the court could easily find the boy's action of running under the circumstances breached his duty of care and therefore find the son negligent. Big Box negligence. The second issue is whether Big Box can be held negligent for failing to monitor the area where the cheesecake was displayed. In addition to people, stores can also be held liable for negligence. However, a store is not liable for every harm that occurs within it. A store will only be liable for negligence when they had a duty, breached that duty, and that breach causes damages. But a store that invites customers into it for business purposes, bring invitees, is held to a higher standard of care as to those invitees that are in the selling area of the store. Generally, courts require places where invitees are to be regularly inspected. Generally, courts require places where invitees are to be regularly inspected for matters that reasonably could cause injury. This does not require constant monitoring, but some form of consistent monitoring is usually required. Further, where there is a dangerous artificial condition, the store has a duty to either fix the condition or warn of it. Here, there are sufficient facts for a jury to conclude that Big Box acted negligently. As a store, Big Box invited customers to it in order for them to purchase things from it. This is why the son and his mom came to the store. Thus, the son and mom were invitees, and Big Box owed a standard of care to them. This standard included monitoring for dangerous conditions. However, Big Box failed to put in place any consistent monitoring system for their store. Because of this, Big Box was unable to discover the cheesecake, which had been flattened and dirty. This was an artificial and dangerous condition that they would know about if they had been monitoring the area. Although a Big Box employee did walk through the area with the cheesecake and failed to discover it, this alone does not excuse Big Box liability and negligence because the fact that employee happened to be in the area with no duty to monitor does not fulfill the store's obligation to its invitees. Thus, the Big Box store had a duty to survey for dangerous conditions, and they failed to implement such a survey. As a result, there was cheesecake left on the floor, which the son slipped on and injured himself. Therefore, a jury will find Big Box acting negligently. Customer's liability. The third issue is whether the customer who came to the son's aid can be held liable without a discussion of the Good Samaritan laws. Generally, a person is not liable for harm caused to another unless they themselves committed a tort or acted negligently. As previously stated, a person is not liable for negligence simply because they cause harm to another. Rather, there must be a breach of some duty. Generally, strangers and bystanders do not owe one another a duty. Someone who rescues another is generally not liable for injuries to the other person unless they acted negligently in rescuing the person. By simply seeing a person injured does not create a duty to rescue. Here, a customer saw that the son had fallen in the store and came to help the son stand up. But in the process, the customer negligently twisted the son's arm and further injured him. Although there is no evidence that the customer hurt the son themselves, Although there is no evidence that the customer hurt the son themselves, no tort, and there is no evidence of a duty between the two, the customer was negligent in rescuing the son. In helping the son to his feet, the customer negligently twisted the son's arm, further injuring him. Therefore, although there was no duty between the customer and son, as they were not related to one another and the customer did not create the peril, because the customer was negligent in the rescue of the son, they can be held liable for such negligence. Okay. Son's recovery from big box only. The final issue is whether the son can receive damages from just big box, as both the negligent actions of big box and the customer each contributed to the son's injury. A negligent actor is liable for all the damages they directly cause, as well as damages that are the foreseeable result of their conduct. Additionally, where two parties act negligently, they are jointly and severally liable for the damages to the plaintiff. This means that the plaintiff may go after one or both parties for payment of their damages. Under such circumstances, if only one party pays the plaintiff, they may go after the other negligent party for contribution. However, the plaintiff need not sue both negligent parties in order to recover from one. Here, the mother, on her son's behalf, could recover from just big box under joint and several liability. This is because big box caused the son to fall by failing to inspect the store, and it was foreseeable that others would come to the son's aid and potentially worsen his injuries. Thus, because the original energy and exacerbation of that injury were actually and approximately caused by big box and resulted in damages to the son, the plaintiff may recover from just big box. Big box is also able to seek contribution from the customer after. That's called, I just read about that. When somebody interpleading, maybe. Is that interpleading? If they try to get the customer to be involved, I'm not sure. Question 2. Carlos, Diana, and Ethan own all the shares of Winery Inc., which is incorporated in State A. They are equal shareholders of the corporation and the only members of its board of directors. They share responsibilities in the corporation's beer and winery. They have no shareholder agreement. Recently, Carlos and Diana decided that it would be a good idea to change the corporation's business model. In addition to producing wines from the corporation's own small vineyard using sustainable organic farming methods, they believe that the business should expand to buy grapes from local vineyards and produce grapes using such methods. They believe this new focus will allow them to attract new customers interested in organic wines. They also see this change and expansion to their business as a way to promote environmentally sustainable organic grape cultivation in the region. To make this shift in the corporation's business, Carlos and Diana have decided that the corporation should become a benefit corporation. A benefit corporation, authorized in many states, is a type of for-profit corporation that defines in its articles of incorporation a social or environmental purpose. Benefit corporation law insulates directors from liabilities for making business decisions that serve this defined social or environmental purpose, even when their decisions may negatively impact shareholder pockets. State A has adopted the Model Business Corporation Act, which does not explicitly provide for benefit corporation. State A courts have held that domestic corporations must seek to maximize shareholder profits. State B, which is adjacent to State A, also has adopted the Model Business Corporation Act, but has modified its corporate statute to provide for the formation of benefit corporations. To form a benefit corporation, the articles of incorporation must indicate that the corporation has opted to be a benefit corporation and must state a social or environmental purpose for the corporation. State B, statute insulates directors from liabilities for claims. Um, State B, statute insulate directors from liability for claims they did not seek to maximum. State B, insulate directors from liability for claims that they did not seek to maximize shareholder profits if their decisions are consistent with the corporation's stated social and environmental purpose. Carlos and Diana have decided that they can best okay. Carlos and Diana have decided that they can best carry out the new business plan by creating a benefit corporation in State B to operate in State A with the stated social and environmental purpose of promoting sustainable and organic vineyard, winery, and production practices. They will incorporate the new benefit corporation as Organic Wines Corp and be its only initial shareholders. Once the corporation is created, they will cause Vinery Inc. to merge into it, and with all that Binary Inc. shares converted, merge into it, with all Binary Inc. shares converted into shares of Organic Wines Corp. Ethan is opposed to the plan, but Carlos today and is supported. And Ethan blocked the merger of Winery Inc. into Organic Wines Corp by voting against it. Explain. I don't think so because he only has one vote. If Winery Inc. merges with Organic Wines Corp, does Ethan have a right to demand that he receive payment in cash instead of receiving shares in Organic Wine Corp equal to the fair shares of his shares in Winery Inc.? Explain. Assume that Ethan becomes a shareholder of Organic Wines Corp. Could Ethan successfully sue Organic Wines Corp for directors in State A for promoting sustainable and organic practices at the expense of maximizing shareholder profits? Explain. Do not discuss whether the suit would have to be direct or derivative. I don't even know what that means. I'm clearly not ready for the test. Ethan cannot block the merger of Winery Inc. into Organic Wines Corp by voting against it. A merger is a fundamental change that generally requires one director approval and then two shareholder approval. Director approval requires that the board give notice to all the parties and hold a meeting to vote on whether the merger is a good idea. A quorum of directors is a majority of the directors. If the majority of the directors are present, then the majority of the present directors must vote in favor. Quorum can be broken if a director isn't present. If it passes, this process is repeated for shareholders. The board must notify all shareholders entitled to vote, and there must be a vote. A quorum of shareholders is a majority of the outstanding. A quorum of shareholders is the majority of outstanding shares. If present, the vote must receive a majority of the outstanding shares entitled to vote, or in some jurisdictions, actually voted. If present, a vote must receive a majority of the outstanding shares entitled to vote, or entitled to vote, or in some jurisdictions, actually voted. Quorum is generally not lost if shareholders leave the meeting. Once this is done, the document of the change must be filed with the Secretary of State reflecting the change. Here, Carlos and Diane are going to change the whole business model and create a new business and merge the old into it. This is a fundamental change and will require approval of the board and its shareholders. Here, Carlos, Diana, and Ethan own all the shares in the winery and are the only members of the board of directors. Therefore, at both a board vote and a shareholder meeting vote, Ethan will be outvoted. Thus, Ethan does not have the ability to block a merger of Winery Inc. into Organic Wines Corp. By voting against it. If Winery Inc. merges into Organic Wines Corp., Ethan has the right to demand that he receives payment in cash instead of receiving shares in Organic Wines Corp. Equal to the fair value of his shares in Winery Inc. Generally, a dissenting shareholder to a merger may demand a buyout if the corporation is small and closely held, not a publicly traded company. Generally, to preserve the ability to do this, the shareholder must: 1, give notice to the board of its disapproval; 2, vote against or abstain from voting in the meeting to merge; and 3, make a request for payment after the vote is finalized. If this is done properly, then the shareholder has the right for the corporation to buy stock, to buy back its shares for fair market value. If the parties cannot agree, that was my next question, is a closely held corporation, who's going to know what proper shareholder value is? Agree to fair market value, then they can petition the court for an appraisal. Okay, here It is a small and closely held company, only three shareholders, and there is no indication that it is publicly traded. Therefore, so long as Ethan properly preserves the right by notifying the board and voting against the decision to merge, Ethan can demand the corporation buy back his shares in the company for a fair market value. In this case, Ethan will sell his shares in Winery Inc. back to them instead of being part of the merger. If they can't agree on a fair value, they will petition the court to appraise it. Assuming that Ethan becomes a shareholder of Organic Wines Corp., Ethan may not successfully sue Organic Wines Corp. Directors in State A for promoting sue the Organic Wines Corp. Directors in State A for promoting sustainable and organic practices at the expense of maximizing shareholder profits. Generally, the law of the state where the corporation is incorporated controls the corporation's affairs. This is known as the internal affair doctrine. The internal affair doctrine is the law of the state where the corporation is incorporated controls the corporation's affairs. This is known as the internal affairs doctrine. This is true no matter where the operations are carried out. All the corporation has to do is register with the state in which it is operating. But all the corporation has to do is register with the state in which it's operating. But the laws governing the affairs, such as the shareholder profit distributions, are going to be governed by the state of the corporation. No matter where the operations are carried out, the internal affair doctrine says the laws governing the affairs, such as shareholder profit distributions, are going to be governed by the state of corporation. Here, State A, where Winery Inc. was incorporated, is controlling. The State A law does not provide for benefit corporations. However, if Organic Wine Corp., the new company, is incorporated properly in State B, then State B will control, and then the benefit corporation are permissible and insulate directors from liability for claims. That they, then State B will control, and then benefit corporations are permissible to insulate directors for liability for claims that they did not seek to maximize shareholder profits if it is consistent with their purpose. Therefore, Ethan will not be able to bring a claim because promoting sustainable and organic practices is the corporation's purpose, and the directors are not liable even at the expense of maximizing shareholder profits. Thus, Ethan may not successfully sue Organic Wines Corporation's directors in State A for promoting sustainable and organic practices at the expense of maximizing shareholder profits. So, Winery, which one was the Winery Inc. was a State A, which didn't recognize benefit corporations, but the neighboring state, State B, recognized benefit corporations. So they created a new winery called Organic Winery Inc., and they merged Winery Inc. into it. So now Organic Winery Inc. is a State B corporation, which does not for benefit corporation. So a shareholder cannot sue the company for failure to maximize profits of a business of a benefit corporation as long as what they're doing is in support of their mission. Right. All right, question 3. 15 years ago, a woman moved to State A for a temporary job. Shortly after moving to State A, the woman met and briefly dated a man who lived in State A. 8 months after her relationship with the man ended, the woman still living in State A gave birth to a daughter. She then moved to State B with her daughter. The woman was certain that the man was the daughter's father because he was the only person she had sexual intercourse with while she was living in State A, but she did not contact him to tell him of her pregnancy or the daughter's birth. The woman had no other children. She and the daughter lived together as a 2-person household exclusively in State B. The woman told her family and her daughter that the daughter's father had been killed in a car accident. 2 months ago, the daughter, age 14, overheard a conversation between the woman and her oldest friend. The friend said, "Your daughter's father is now an important scientist. His most recent research is in today's newspaper. Don't you think your daughter should meet him?" The daughter, shocked, found the newspaper and emailed the scientist whose research was described in the paper. In the email, she identified her mother, recounted the conversation she had overheard, and suggested DNA testing. The man agreed to cooperate, and the test confirmed that he was the daughter's biological father. The daughter told the man that she wanted to live with him at his home in State A. The man, wanting to get to know his daughter better, agreed and sent her a bus ticket, which she used without her mother's permission. 3 weeks after the daughter's arrival in State A, the man sued in a State A court to establish his paternity to gain sole custody of his daughter and to obtain child support from the woman. The man had the woman served personally in State B. What? Under under state A's long arm statute, the state may exercise personal jurisdiction over a non-resident for purposes of determining paternity, child custody, and child support if the individual engaged in sexual intercourse in the state and the child may have been conceived by that active intercourse. State A's paternity statute permits the mother or alleged father to establish paternity at any time during the mother's pregnancy or within 21 years after the child's birth. The woman moved to dismiss the man's suit, arguing that state's aid exercise of personal jurisdiction over her would violate her rights of due process clause of the 14th Amendment. The trial court denied her motion, and the woman made a special appearance, preserving her right to appeal on the jurisdictional issue. At a hearing on the merits, the woman argued, based on a series of United States Supreme Court opinions, that a putative father may not establish his paternity years after his child's birth unless he that a putative father may not establish his paternity years after his child's birth unless he registered with the putative father registry or actively participated in his child's care. She also argued that the court lacked authority to issue either a child custody or a child support order. Number one, did state A's court's exercise of personal jurisdiction over the woman violate her rights under the due process clause of the 14th Amendment? Explain. Assuming the state A court properly exercised personal jurisdiction over the woman and the man's paternity is undisputed, does the court have subject matter jurisdiction to, one, award the man sole custody of the daughter? Explain. Or two, require the woman to pay the man child support? This is such a cool question. Oh my goodness, this is such a cool question. Okay, so we have found the question that we are going to use for the essay that we are going to submit to the Vermont Judiciary. And what I'm so excited about is the fact that I understand that this is civil procedure, even though it doesn't say that this is a civil procedure question, because we're talking about personal jurisdiction, we're talking about the due process clause of the 14th Amendment, and we are talking about subject matter jurisdiction, right? So I'm not going to look at the answer until after I do my questions. I'm just going to move on to the next one and read it, but I'm super excited about it. So yeah, I'm super excited about it. Great. Question. A police officer patrolling in his squad car after dark saw a woman lying on the sidewalk near an intersection. A teenage girl standing near her yelled, "Help!" The guy just knocked this woman down and took her purse. The girl pointed toward a man carrying a white purse and sprinting away from the scene. The officer jumped out of his squad car and shouted, "Stop, police!" He ran after the man down the alley in between houses. The man leapt a series of backyard fences and ran onto a back porch. The officer followed behind, jumped over the low fence, heard the man fumbling with keys, and saw him unlock the door of the house. The man rushed inside and slammed the door. The officer tried to open the door, but it was locked from the inside, and the man yelled, "Get off my porch." The officer kicked the door open. The man was standing just inside the door, out of breath, with a white purse on the floor near his feet. The officer handcuffed the man, grabbed the purse, and walked the man back to the intersection where the woman was sitting on a nearby bench. The teenage girl was gone. The woman immediately said, "That's my purse." Then she asked the officer, "Is this the guy who took it? I never saw anything. Someone pushed me hard from behind, knocked me down, grabbed my purse, and took off. I was dazed and just lay there until some girl helped me up." The officer told the man that he was under arrest and placed him in the backseat of the squad car. Another officer arrived a few minutes later. The teenage girl returned. The girl began speaking with the second officer, saying, "I was right there. It happened really fast. One second I was waiting for my bus and reading text messages. The next second I heard a woman scream and saw some big guy running past me with a purse." The girl then noticed the man handcuffed in the backseat of the squad car. She shouted, "Oh my gosh, hey, I think that's the guy. It was dark and it happened fast, but wow, he's right there in the car. I'm pretty sure that's the guy." The state charged the man with one count of robbery under the state statute that defines the crime as it was defined under common law. The state charged the man with one count of robbery under the state statute that defines the crime as it was defined under common law. Relying only on his rights under the United States Constitution, the man has moved the trial court to suppress evidence of the purse and the officer's testimony about where the officer recovered it. The man argued specifically that the officer's entry into his home without a warrant violated his constitutional rights. The man has also moved the court to prohibit any witness from discussing the girls on the scene's identification of him and to prohibit her from identifying him in the court during the trial. He argued specifically that allowing evidence of the teenage girl's identification would violate his constitutional rights. Number one, did the officers warrantless seizure of the man and warrantless seizure of the purse in the man's home violate the man's 14th Amendment rights? Number two, would the trial court violate the man's constitutional due process by admitting testimony that reveals the girl's on the scene identification of him or by allowing her to identify him in court? Explain. Do not discuss any confrontation clause issues. I like the way that they tell you where not to go and they give you these little like clues. That's kind of cool to me. Okay. Answer. Issue one. Was the officer's warrantless seizure of the man and the warrantless seizure of the purse in the man's home a violation of the man's Fourth Amendment rights? The officer's warrantless seizure of the man and warrantless seizure of the purse in the man's house did not violate the man's Fourth Amendment rights, as the officer was in hot pursuit of the man and had probable cause. Generally, police officers are required to have a search warrant to search an individual's premises. A warrant issued by a neutral magistrate based on finding of probable cause. In addition, probable cause that a crime has been committed is necessary to arrest an individual. However, there is an exception to the warrant requirement for exigent circumstances.
Exigent.
Exigent, pressing or demanding circumstances. Exigent. Okay. However, there's an exception to the warrant requirement for exigent circumstances. For example, an officer in hot pursuit is not required to get a warrant prior to entry of a home. Once in the home, the officer is permitted to arrest the man and seize items in plain view and conduct a protective sweep. Seizure of the man. To seize an individual, police officers need either an arrest warrant or probable cause that a crime has been committed. An individual is considered seized if they are in custody of the police and not free to leave. The officer had probable cause to believe that the man had committed robbery, the taking and carrying away of the personal property of others by force or threat of force or from someone's person, and therefore did not need an arrest warrant to seize him. The police officer found a woman lying on the sidewalk near the intersection while patrolling in his car. A teenage girl nearby yelled, "Help." The guy just knocked this woman over and took her purse while pointing to the man carrying a white purse and running from the scene. This is sufficient to establish probable cause. Here, the officer had probable cause to believe that a crime had been committed as the woman was laying injured and a nearby bystander informed the police officer that a man had taken the injured woman's personal property by force. In addition, the police officer had probable cause to believe that the man in question committed the crime. The man was pointed out to the officer by the young girl who was near the scene. When the police identified himself, the man continued running. While running away alone is insufficient to find probable cause, the fact that the man ran away, coupled with the identification of the man, gives rise to probable cause that the man committed the crime. So it's not just running away, but it's running away and identification of somebody else that gives you probable cause. The police officer was permitted to enter the house to seize the man as he was in hot pursuit, and therefore an exigent circumstances existed. See below for more discussion on the hot pursuit. Thus, there is probable cause to seize the man, and the officer was permitted to enter the house based on exigent circumstances. Seizure of the purse. To justify a warrantless search of the premises, there must be exigent circumstances, including hot pursuit of a suspect. This arises when an officer is actively chasing a subject and does not have the time to stop and seek a search warrant from the court for fear of losing the evidence. An officer searching a house in hot pursuit may look for the evidence of the crime in plain view and conduct a protective sweep of the premises. In addition, the police officer is allowed to seize anything that, from a legal vantage point, is plainly illegal or contraband. The officer was in hot pursuit of the man and was therefore permitted to enter the home and seize the purse without a warrant Here, the officer was chasing the man, and the man jumped over a series of backyard fences before running into a back porch. I would have said one, two, but anyway, the officer followed the man and saw the man unlock the door and rush inside. The man yelled, "Get off my porch." However, the police officer kicked the door down and discovered the man standing just inside the door with the right purse on the floor of his feet. The officer was permitted to break into the house because he was in high pursuit of the suspect. Had the officer left the scene for a warrant, the man could have been long gone, and so would any evidence of the crime. In addition, the purse was in plain view as the officer was legally permitted to enter the home to arrest the man. The purse was right next to the man's feet and appeared to be the purse the man was holding when he ran from the scene and when the teenage girl indicated that the man robbed the woman. Thus, it was plainly evident that the purse was contraband and could be seized. Further, the purse actually was the woman's. After the officer walked the man back to the intersection, the woman immediately identified her purse. It is irrelevant that the woman could not identify the man as her attacker, as there was sufficient probable cause without her identification. Thus, the officer was permitted to seize the purse. Issue two. Would the trial court violate the man's constitutional due process rights by admitting testimony that reveals the girl's on the scene identification of the man or by allowing her to identify him in court? The trial court would not violate the man's constitutional due process right by admitting testimony that reveals the girl on the scene's identification of the man or by allowing her to identify him in court because the witness has actual knowledge and that identification was not impressively suggestive. Defendants are entitled to constitutional protection of their due process rights under both the Fifth and the 14th Amendment of the United States Constitution. One way to violate a defendant's due process rights in a criminal context is to permit an impermissibly suggestive and tainted identification of the man into court. However, prior out of court identifications are permitted to be used in court if they are fair identifications.
Impermissible.
Okay, so one way to violate the defendant's due process right in a criminal context is to permit an impermissibly suggestive and tainted identification of the man into court. However, prior out of court identification are permitted to be used in court if they are fair identifications. On scene identification and impermissibly suggestive identification is not allowed to be admitted into evidence unless the state can prove that even without the suggestiveness, the individual would have picked that person. The opposing side must be given the chance to cross-examine the individual who gave that out-of-court identification for due process to be satisfied. The opposing side must be given the chance to cross-examine the individual who gave the out-of-court identification. Okay. Admission of the teenage girls on the scene identification would not violate the man's due process rights, as identification was not unfairly influenced and was spontaneous. While placing the man in custody creates a suggestive atmosphere. The girl's identification was spontaneous. And therefore admission would not violate the man's due process rights. Here, a few minutes after the officer had arrested the man, a teenage girl arrived and began speaking to a second officer and stated, "I was right there. It happened really fast. 1 second, I was waiting for my bus and reading text messages. The next time I heard a woman screaming, I saw a big guy running past me with a purse. After the girl noticed the man, she shouted, 'Hey, I think that's the guy.' It was dark and it happened fast, but wow, he's right there in the car. I'm pretty sure that's the guy." Thus, the girl spontaneously identified the man. The cops did not ask her if the individual they arrested was the man, and therefore, even though the environment might have been suggestive, the police did not create or cause the suggestive environment. However, if the on the scene identification is permitted in court, the fact that the girl was not entirely sure that the man arrested is the correct man must be included. She never definitively stated that the man in custody was the attacker, and thus it cannot be stated with specific certainty that she identified the man at the scene. Thus, the out-of-court identification is permitted subject to the girl being available for cross-examination on her out-of-court statement. Okay, so we're back. However, if the on-scene identification is permitted in court, the fact that the girl was not entirely sure that the man arrested is the correct man must be included. She never definitively stated that the man in custody was the attacker, and thus it cannot be stated with specific certainty that she identified the man at the scene. Thus, the out-of-court identification is permitted subject to the girl being available for cross-examination on her out-of-court statement. Identify him in court. Out-of-court identifications that are tainted do not necessarily prevent an in-court identification. In-court identifications do not violate due process as they are based on personal knowledge. The girl can identify the man in court as the person she likely saw. However, unless she later remembers that the man is exactly who the suspect was, she is limited to the identification she made at the scene. She may also testify based on her personal knowledge. At the time of her original identification, her personal knowledge only extended to the thought that the man was the suspect in question and that she was pretty sure. Thus, absent a clear memory, the girl cannot later testify that the man is exactly who attacked the woman. Thus, the in-court identification is permitted. Question 5. 8 years ago, a testator validly executed a will. The will, in pertinent part, provided: 1, I give my house to my friend Doris. 2, I give my residuary estate in equal shares to my friend Alice if she survives me, and to my friend Bill if he survives me. If any beneficiary under either of the foregoing two provisions of this will precedes me, and my will does not expressly provide otherwise, the heirs of the deceased beneficiary shall take the beneficiary's bequest. 3 years ago, Bill and Doris died. Doris died testate, bequeathing her entire estate to charity. If Doris had died intestate, all her probate assets would have passed to her nephew, her sole heir. Bill died intestate, and his entire probate estate passed to his daughter, his sole heir. Last week, the testator died domiciliary of state A, leaving a probate estate consisting of her house and a bank account balance of $250,000. The testator died with no debts. State A's anti-lapse statute provides in its entirety, unless the decedent's will provides otherwise, if a bequest is made to a beneficiary who precedes the decedent, leaving issue surviving the decedent, the deceased beneficiary share passes to the issue of the deceased beneficiary. The testator is survived by Doris's nephew, Bill's daughter, and Alice. The only relative of the testator who survived the testator is her sister. The only relative of the testator who survived the testator is her sister. The charity to which Doris bequeathed her estate still exists. Does the state's anti-lapse statute or clause 3 of the testator's will determine who takes the share of the beneficiary who preceded the testator? Explain. Assuming that clause 3 of the testator will applies, who is entitled to the testator's house? Explain. Does the residuary bequest to Bill lapse because of the express survivorship requirement in clause 2 of the testator's will? Explain. Who is entitled to Bill's 1/2 share if the bequest to Bill lapses? Explain. Who is entitled to Bill's 1/2 share if the bequest to Bill does not lapse? Explain. Wow, this is deep. Application of the anti-lapse statute or clause 3. The issue here is whether a state's anti-lapse statute or a specific clause in a testator's will that expressly states where a bequest should go in the event a beneficiary precedes testator governs. Here, it is likely that clause 3 of the testator's will governs rather than the state's anti-lapse statute. Anti-lapse statutes are enacted in states to prevent a testator's bequest from lapsing to the residuary estate and instead passing to the beneficiary's heirs or issues. In the present case, state A has an anti-lapse statute that includes the language unless the decedent's will provides otherwise. Here, testator will expressly says what should happen if one of the beneficiary precedes the testator. Thus, the anti-lapse statute does not apply to the testator's estate. Thus, the anti-lapse statute does not apply to the testator's estate, should be distributed pursuant to the will and its clause 3. Clause 3 states that that in the event a beneficiary precedes a testator, the heirs of the beneficiary take the bequest. As such, any of the gifts that are subject to Clause 3 shall be governed by Clause 3 and not the anti-left statute. Testator's house. Here, the testator's house is left as a specific device to Doris, but Doris has preceded the testator. Under Clause 3 of the testator's will, the gift will go to her heir. While Doris left her estate to charity, the charity is likely viewed as a devisee of Doris, not an heir. For this reason, it is likely that the house will pass to Doris's nephew, as he is Doris' near relative and therefore heir. The language of the testator's will says heir rather than devisee, so it is likely that testator intended for any gifts made in her will to stay in the family of the beneficiaries. Residuary bequest to Bill. The question here is whether the wording, if he survives me, should be constructed as being a requirement to a gift. As already determined, the testator will suggest that any gift to the beneficiary who passed before the testator should go to the deceased beneficiary's heir. However, it is unclear whether the testator's language, if he survives me, suggests that surviving the testator is a condition for Clause 3 to apply. Since it appears that the language presents a condition, it is likely that the gift will lapse in the state without an anti-lapse statute. However, because of the anti-lapse statute in State A, the gift will be saved and passed to his heir, discussed further below. Even though the anti-lapse statute likely does not apply to most of the testator's estate because of Clause 3, it is likely that the court will save any gift that is not protected by Clause 3 under the anti-lapse statute. Bill's 1/2 share if the bequest lapses. The question here is what happens to a bequest that lapses. Generally, a gift that lapses goes into the testator's residuary estate. The residuary estate is made up of the remaining assets of the testator, not generally or specifically gifted, and not used to pay off any remaining expenses. Since the testator died without debt, the entirety of the 1/2 bequested bill will lapse to the residuary estate. Here, the residuary estate is specifically gifted to Bill and Doris. Thus, Bill's 1/2 share will likely pass to Alice. However, if a court interprets the will to suggest that the gift is to be construed as meaning Alice is only entitled 1/2 and the residuary and nothing more, Bill's 1/2 of the residuary will pass in accordance to State A's intestacy statute. Since the testator is survived by her sister and is unmarried and without any issue, any intestate statute would likely result in the sister as the daughter of the testator's parents receiving any intestacy property. Bill's 1/2 share if the bequest does not lapse. The question here is regarding when a bequest does not lapse, but the beneficiary precedes the testator and dies intestate. In the event that Bill's 1/2 share does not lapse, his bequest of the 1/2 of the residuary estate will pass to Bill's sole heir, his daughter. Regardless of the intestate statute in State A, his daughter will take because she is the issue of Bill as well as the only surviving heir of Bill. Thus, the daughter will take in the event that the testator's gift to Bill is construed such that it does not lapse. This is complicated. Oh, probate is complicated. All right. Question 6. Let's get to reading. A 55-year-old woman has been employed for 30 years as a paralegal at a law firm in State A. 1 year ago, a 28-year-old male attorney became the firm's paralegal manager. The attorney began criticizing the woman's work and berating her on a nearly daily basis. He made derogatory comments about her work. Oh, I read this before. He made derogatory comments about her and her work to the other paralegals and attorneys in the firm. He nicknamed her grandma and told people that it's time for the new generation to take his place here. 3 months after he took over as paralegal manager, the attorney fired the woman. To replace her, he hired a 22-year-old paralegal. He explained the firing to his coworkers by stating that the woman had stolen valuable supplies from the firm and was neither honest nor trustworthy. After exhausting all prerequisite administrative remedies, the woman filed an action in the U.S. District Court for the District of State A. Her lawsuit was against the attorney who had fired her. The woman's complaint states 2 causes of action. First, the complaint asserts the attorney fired her because of her age in violation of the Federal Age Discrimination and Employment Act, ADEA, of 1967, under which the attorney is considered an employer. Second, the complaint alleges that the attorney made defamatory comments about the woman to the other employees of the law firm, thereby committing a tort under State A law. In particular, the woman's complaint alleges that the attorney made comments to others to the effect that the woman was dishonest and a thief, and that such comments were false and defamatory. The woman's allegations include the approximate dates and comments and the identity of the persons whom they were made, but the complaint does not recite the exact allegedly defamatory language used by the attorney. The attorney and the woman are both citizens and domiciliaries of State A, where the law firm's offices are located and where all the events in this matter took place. All right, so personal jurisdiction. State A pleading rules require a plaintiff's defamation claim to allege the time and place where the allegedly false statements were made, the persons to whom they were made, and the particular words constituting defamation. She has a problem. She didn't do that. State A courts apply these rules strictly and dismiss complaints seeking damages for defamation if the specific words that are alleged to be defamatory are not stated in the claim. All right, so that's going to be dismissed. The attorney concedes that the court has federal question jurisdiction over the woman's ADA claim, but has moved to dismiss the defamation claim. The motion to dismiss argues one, that the federal court lacks jurisdiction over the defamation claim because it is based entirely on state law, and two, that the woman did not allege the particular words constituting defamation as required by State A. Number one, should the federal court grant the attorney's motion to dismiss the woman's defamation claim on the ground that the federal court lacks jurisdiction over the claim because it is based solely on state law? I'm not sure about that, and I kind of don't. I want to do this one out, at least some of the questions, because I think I know the answer to this. But you can have supplemental jurisdiction over a subject if the first case is you have federal subject matter jurisdiction, I think. Should the federal court grant the attorney's motion to dismiss the woman's defamation claim on the ground that the woman did not allege the particular words constituting defamation as recorded by State A? All right, so yeah, so those two I actually want to do. I'm going to try to get up and start working on them. I think I'm going to work on this one first because I think it's a little bit easier. Let me see how much they wrote. Yeah, they wrote like a little bit over a page. So I think I'm going to get up and do that one tomorrow morning and then really work on the other one for submission. So wow, this was super helpful to look over these questions, and I'm very excited. So we will actually go and start reading through the MPT questions too. Alrighty. So that sounds great. All right. Thank you so much for tuning in to today's episode of Legally Direct, Legally Raven Haired, signing off.